Hi, my name is Andrew Meinzer of Meinzer Law Firm PC. Today I'm going to talk with you about how to manage a vacant family house when you're managing the affairs of another person in California through a trust, probate decedent estate court proceeding, or conservatorship court proceeding. I'm not going to explain in this video what these proceedings are all about. We've published many videos here that explain them in detail. This is the second video of a two-part video series. In the first video, we provided you with rules and information. In this second video, we'll demonstrate how those rules apply to a set of real-world facts. What we're discussing here is what I call the vacant home dilemma, and it can get you into trouble if you're not careful. It arises all the time, and most often in the context of a trust. So we'll concentrate on the trust context here. How does the family house end up vacant in the first place? Well, here's how it often happens. Let's say that mom and dad bought a house and lived in it for 50 years. They had 3 children, and they raised all 3 children in the house. The value of the house increased greatly in those 50 years. The fair market rental value of the house now is $3,000 per month. Mom and dad created a trust, naming their son Rusty, trustee, to be in charge of carrying out the trust after mom and dad can't do it anymore. The trust also provides for all assets to go to their 3 children, Rusty, Tina, and Scooter, after mom and dad both are deceased. Then dad died. Shortly after dad died, mom suffered a stroke. Mom had to move out of the family house and into a skilled nursing facility, and she's not going to be returning to live in the family house. Rusty had to take over as trustee of the trust to manage all trust assets for mom. Rusty, trustee, has his hands full raising his kids and managing mom's finances. He leaves all of mom's furnishings in the house and leaves the house vacant for 36 months. Rusty's sister Tina has become exasperated because she needs to chip in with Rusty to pay for many of mom's expenses. She's also paying college tuition for 2 of her children, and she's low on cash. And Tina's especially bothered because she feels that the family house shouldn't be sitting dormant under these circumstances. She's had many conversations with Rusty about this, and Rusty always tells Tina that he's just too busy to deal with it. After a few months, Tina can't take it anymore. She files a petition with the court to have Rusty removed as trustee and surcharged. Surcharged means have to pay out of your personal funds for a mistake that you made to replace the money that was lost due to the mistake. Rusty, trustee, could find himself in trouble in these facts. He could be violating his duty to preserve property of the trust estate and his duty to make that trust property productive. A court could order him to pay $108,000 of his personal funds into the trust as a surcharge to replace the lost rent. That's $3,000 per month times 36 months. Most likely the surcharge would not be for that maximum amount. It would be reasonable for Rusty to wait a few months after mom went to the skilled nursing facility before Rusty determines whether to keep the house available for mom or to rent it or to sell it and invest in net sale proceeds. It may be reasonable to wait and make sure that mom will not need to return to living in the family house. And then it would take time to clean out the house if mom is in fact not going to return to it. Now, Rusty, trustee, essentially still has the same problem if dad and mom had both died at the same time and Rusty allowed the family house to remain vacant and unrented for 36 months. Remember that in that situation, the trust provides for all assets to go to Rusty, Tina, and Scooter equally. Rusty could be liable to each of Tina and Scooter in the amount of $36,000. The fair market rental value of the family house is $3,000 per month. Thus, each month that Rusty does not receive any rent for the family house, it's essentially the same as him taking $1,000 out of the pocket of Tina and $1,000 out of the pocket of Scooter. You may have noticed that only Rusty and Tina chipped in to pay many of mom's expenses. Were you wondering about Scooter? Scooter didn't chip in because he never has any money. In fact, he's 50 years old and he's always lived in the family house with his parents rent-free. Rusty, trustee, is taking a risk if he allows Scooter to continue living in the family house rent-free, especially after the death of mom. Rusty, trustee, could be violating his duty to treat all trust beneficiaries impartially. Rusty, trustee, may need to evict Scooter from the family home. That's the difficult reality in some of these cases. If Scooter lived rent-free in the family house after the death of both Dad and Mom, then Rusty may be able to offset the amount that Scooter inherits from the trust by the reasonable value to Scooter of him living rent-free in the family house since the time of Mom's death. The vacant house dilemma is only one of many things that can get the trustee of a trust, the conservator of a conservatorship court proceeding, and the administrator or executor of a probate decedent estate court proceeding into trouble. Don't risk personal liability by making this type of mistake. Hiring an experienced attorney, an attorney that's experienced with trusts, conservatorship court proceedings, and probate decedent estate court proceedings can keep you out of trouble. At Meinzer Law Firm PC, we have over 20 years of experience helping clients achieve their goals in trust cases, conservatorship court proceedings, and probate decedent estate court proceedings. Contact Meinzer Law Firm PC to assist you.